Welcome to my channel. Just like, comment, and subscribe. In this video, we are going to talk about maritime injuries and death. No law firm in a country has handled more maritime cases than the Busby Law Firm. Our maritime injuries and death attorneys in Texas have handled multiple cases involving maritime injury and wrongful death against Wicks Marine, Callan Marine, Great Lakes Stretch and Dock, Orion, Mars, Diamond Offshore, BP, H&P, Global Santa Fe, Transocean, Rowan Drilling, and many other maritime companies. If you need an experienced maritime lawyer, someone who knows what they are doing and knows how to win, the Busby Law Firm should be your first choice. The Busby Law Firm has also tried more of the case and have the largest verdicts even entered in the United States in these types of cases. We know barges, crew boats, supply boats, drill ships, push boats, tow boats, dredges, jack-up rig, and all types of other vessels. We know all the right experts and the law. We try these cases all the time and rarely lose and call us. Maritime injuries and death. A career in a maritime work can be very rewarding but also dangerous if you suffered injuries as a maritime worker or lost a loved one. You may be entitled to compensation. Consult with the Texas Maritime Injuries and Death Attorneys to learn what legal option you have to pursue damages. Maritime injuries and death, like no firm in the country has handled more maritime cases than the Busby Law Firm. Our maritime injuries and death attorneys in Texas have handled multiple cases involving maritime injury and wrongful death against Wicks Marine, Callan Marine, Great Lakes Stretch and Dock, Orion, Mars, Diamond Offshore, H&P, Global Santa Fe, Transocean, Rowan Drilling, and many other maritime companies. If you need an experienced maritime lawyer, someone who knows what they are doing and knows how to win, the Busby Law Firm should be your first choice. The Busby Law Firm has also tried more of these cases and have the largest verdicts ever entered in the United States. In these types of cases, we know barges, crew boats, supply boats, drill ship, push boat, tow boats, dredges, jack-up rigs, and all types of other vessels. We know all the right experts and the law. We try these cases all the time and rarely lose and call us. Why choose the Busby Law Firm to represent you? Maritime law is ancient, originating before the creation of the United States, and complicated. With headquarters in Houston and Galveston, Texas, and through the experience of representing hundreds of Jones Act seamen and other maritime workers, our attorneys know maritime law. Our firm's founder, Tony Busby, is recognized as one of the best on the Gulf Coast. And the damages you can seek under the federal maritime law in Texas. There are laws meant to protect injured seamen, dock workers, longshoremen, and other workers in the maritime industry. These laws provide a means for them to recover damages for injuries sustained on the job. The laws also allow dependents to collect compensation if their loved ones dies in an accident while they are working. These include the Jones Act. This federal law specifically covers seamen and workers who sustain injuries while at sea, on offshore rigs or dock ship, and on other offshore installations. The Jones Act allows injured workers to file a claim and receive compensation for the following: current and future medical costs, loss of earning capacity, mental anguish, disfigurement of scarring, physical pain and limitation caused by the injury. To get your compensation, you only need to prove that your employer was in some way negligent in their duty of care, and because the burden of proof is low, you only need to show that your employer's carelessness, even in the smallest of ways, led to injuries while at sea. The Jones Act also covers wrongful death benefits, so if a worker dies from injuries sustained in an accident while at sea, dependents of the deceased seamen can claim certain damages against relatives of the deceased. Only need to prove that the employee's negligence resulted in the death of their loved one. And then death on a high seas act. If a maritime employee's carelessness led to a seaman's wrongful death while they are at least 3 nautical miles away from the shore of the United States. The Death on a High Seas Act (DOHSA) provides something called survivor's rights to benefits. This allows a certain surviving relation to claim the benefits covered under the Act, but the dependent have to prove wrongdoing or negligence before they can claim the wrongful death benefits. Even if there is a proof of contributory negligence by deceased, the law still mandates the provision of those benefits to the surviving relatives. Although the deceased's negligence might mean a lower settlement amount, and then the damages that beneficiaries can claim include funeral expenses, lost present and future financial support for beneficiaries, loss of income and benefits that the deceased owed the dependents, cost of mental health expenses necessitated by the death of the benefactor, additional household maintenance costs. However, there are limitations to the damages that the relatives of the seaman who died can claim, as well as the qualifying circumstances. For instance, surviving family members cannot claim no economic damages like mental distress, grief, or pain and suffering. The Act also applies to commercial sea vessel workers, so if someone dies at sea aboard a vessel or aboard a private or non-commercial vessel, the family members cannot claim this compensation. Death on a High Seas Act coverage extends beyond ships and seas to aviation and commercial airplane crashes too. But to qualify for compensation under the Death on a High Seas Act, the airplane accident must occur at least 12 nautical miles away from the shores of the United States, and even then, relatives can only claim non-economic damages under the Death on a High Seas Act. And then the Longshore and Harbour Workers Compensation Act. The Longshore and Harbour Workers Compensation Act, or LHWCA, provides benefits to dock and harbor workers, longshoremen, shipping your staff, and other ports workers who are not covered by the Jones Act. There are maritime employees who do not qualify as a seaman but are part of the ecosystem that makes up the maritime sector. If you become ill or are injured while working with a seaman or in some capacity in the ports, shipyards, or docks, the LHWCA can provide benefits such as 7% of your weekly wages for as long as it takes for you to recover, medical expenses, compensation for permanent injuries, scarring and disfigurement, permanent partial disability damages. In summary, the LHWCA provides a more robust workers' compensation than what's offered by the state. But to get these benefits, you must first pass the status test, a test proving that you work fall under the job categories covered by the LHWCA. Our maritime injury attorneys at the Busby Law Firm can help determine if you qualify for the Longshore and Harbour Workers Compensation Act. And then the Outer Continental Shelf Lands Act. This is an extension of the LHWCA that covers workers who are injured or deceased while working on offshore areas that are known as Outer Continental Shelf. The Outer Continental Shelf is the part of the United States extending from the land into its territorial waters and is at least 3 to 9 miles off the baseline of the coast of Louisiana, Florida, and Texas. So, workers who become ill, are injured, or are killed while working on temporary or permanent fixtures in the Outer Continental Shelf may qualify for compensation under this law. Unlike the Jones Act, there is no need to prove negligence or fault. The worker only needs to have been injured while working in a region to qualify for benefits such as wage loss, medical cost, temporary or permanent partial disability, temporary or permanent total disability, survivor's benefit if the worker passes from the injuries or is killed while on the job. Maintenance and cure law. This law specifically caters to individuals who work on vessels, offshore rigs, and other offshore installations. The maintenance and cure law ensures that workers are catered for while they are working in this work offshore location. And under the maintenance and cure law, employers must provide the following benefits: adequate shelter and feeding, medical treatment in the event of an injury or illness. Injured or ill workers can receive treatment from their preferred medical providers. Daily wages subject to contract rates while the injured employee heals. Workers do not need to prove negligence or fault to get these benefits. The only basis for receiving maintenance and cure benefits is for falling sick or suffering or injured while working aboard the rig or vessel. That's all guys, thank you so much for watching. Don't forget to give like, comment and subscribe. Bye bye.